All right, so let's continue on with our lecture on the issue of free speech. So, the major sort of one of the most major court cases that determined how free speech would work is Pickering versus the Board of Education. So, in Pickering versus the Board of Education, um, let's see, the case concerned a teacher who wrote a letter to a local newspaper criticizing efficiency and the school board's funding priorities and subsequently was dismissed for disloyalty and insubordination. The court found that the letter addressed a matter of public concern and had not duly disrupted operations of the school district. So this is where the free speech ideology comes in. If you have issues, you can use free speech, or your free speech right has certain restrictions on it if it in any way disrupts the workings of the organization. So if you work for the FBI, let's say, and you are working with classified information, you cannot just go ahead and start discussing and openly talking about the classified information. If you are a professor of public administration and you are examining public administration policies or public policies, of certain governments, you may criticize the policies, but you criticize the policies from a policy perspective, but not necessarily criticize policies from a political perspective, demonstrating your political leanings. So our free speech is curtailed because of the kind of jobs that we do. We cannot religiously, let's say we go against a particular ruling of something as, for example, as LGBT, gay marriage, and we cannot just say, well, I'm against gay marriage, and as a result, even though I'm the person who's supposed to give out the marriage licenses, I'm going to roundly talk about how bad it is and how it's against my religious beliefs in the courtroom. So the idea is that at the same time, there are two ways that we can say, maybe your free speech cannot be curtailed. And those two ways are, first of all, is this a matter of public concern, which means, say we are discussing issues of racism in our lectures, and certain racist things happen across campus, or in our program or in our department, certain policies are seen as discriminatory. And I bring those policies to light and criticize them and talk about them and say, well, these policies are impacting the efficient operation of our department. So in those cases, if I've spoken on a matter of public concern, no action can be taken up against me because it was a matter of public concern. Now, while I'm talking about it, I have in no way impacted the operations of the MPA department. I mean, the MPA program. I've not stopped coming to classes, or I've not stopped, teaching my material. So at the same time, I have not disrupted the operation of the organization. So based on these sorts of things, the one balancing act is: has the employee spoken on a matter of public concern? And does the disruptive nature of the speech justify the adverse personnel action? Which means that if they take some action against me, is it because the disruptive nature of the speech was such that it did impact the operations of the university and it wasn't a matter of public concern? And if it did, then that's fine. But if they're taking some adverse personal action without those two ideologies, then they can no longer do that. There are some other really good cases. The Garcetti versus Sabalas case, which is also a pretty good idea of what isn't and what is not protected by the First Amendment. I don't know if they talk about it over here. No, they don't. And it's a really interesting case. So I really want you guys to kind of take a look at it. And it shows that, some things are protected by the First Amendment's rights. But if you receive a demotion on the basis of your performance, then you cannot claim, that my free speech was in any way curtailed. In addition to curtailing your free speech, there are other protections that public organizations have to offer, one of which is, of course, the Whistleblower Protection. And this shields federal employees' disclosures of gross mismanagement or waste of funds or misuse of funds if there is a danger to public safety or health. But there is a route that you have to take in order for you to get there. You can't just start talking about it and send it to the press. you must seek assistance from the U.S. Office of Special Counsel, right? And the U.S. Office of Special Counsel then lets you know where to go. Even if the U.S. Office of Special Counsel goes against your understanding of it being a whistleblower, you can still appeal to the Merit Systems Protection Board, and they need to prove that in some way, if they fired you because you were a whistleblower, that the action was retaliatory. So I believe it is on page 865, where almost all jurisdictions have enacted legislation protecting personnel from retaliatory adverse action when in good faith they oppose to agency misconduct. But safeguards, as the book says, are limited. For example, the Whistleblower Protection Act shields a federal employee's disclosure of mismanagement, waste of funds, illegal, acts, so on and so forth. But the victim must seek assistance from the U.S. Office of Special Counsel. If unsatisfied, the whistleblower may request a hearing before the U.S. Merit Systems Protection Board, where the person must pay for an attorney and prove that the adverse action was retaliatory. An employee may not initiate a civil action for money damages in court, so you can't still ask for money. In 2012, a unanimous Congress passed President Obama signed the Whistleblower Protection Enhancement Act, which closed judicially created loopholes to and enhanced and broadened the protections afforded to employees under the original Whistleblower Protection Act. Generally stated, the amendments clarified what disclosures receive protection, enhanced the remedies available to a whistleblower, and provided procedural enhancements which benefit employees. State whistleblower statutes vary, and some, such as Florida's Public Whistleblower Act, provide for temporary reinstatement or full reinstatement, back pay, lost benefits, and attorney's fees. So, depending on the federal law, depending on state law, you can go in different places based on your whistleblower, protections. Additionally, we talked about the idea of political activity, and if an employee, as this is an election year, wants to go ahead and engage in political activity, there are certain limitations, and the Hatch Act 939 sort of limits the political activity you can engage in. So I can't wear the name of a certain political candidate on my shirt as I walk in. I can't talk about this political candidate during my lectures and say, well, if you don't believe in this political candidate's points of view, then you will be downgraded in your work. At the same time, government is large, and there are a lot of people that work for government. When you look at state, federal, state, county, and city governments. So there is a Hatch Modernization Act, which allows most state and local employees to run for partisan political office. And initially, Congress has also retreated from some initial broad restrictions because it feared that denying so many Americans, because as I said, there's so many Americans that work for public offices, their right to engage in political activity was negatively affecting the quality of democracy. So with that change, the Federal Hatch Act no longer prohibits state and local government employees from running for partisan office unless the employee's salary is paid for completely by federal loans or grants. So you can't run for political office if your money is coming from the federal government. If your money is coming from state monies or city and county monies, you can still run for federal government. So that's kind of, a good thing that we know about. So, we just need to kind of make sure that there is the onus here is political coercion, which is that is there political coercion where you are using your power in some way to politically coerce constituents or people that are working under you or people that you are influencing to vote for a particular partisan political party. Additionally, though, there are two kinds of federal employees, and you have restriction employees and less restriction employees. And Exhibit, I believe, 2.3 in the book talks about the different kinds of restricted and less restricted employees. But there are some employees that work for intelligence communities or enforcement type agencies, and they don't have that much ability to participate in partisan politics. Less restricted employees do not have such sorts of issues. So the Branti versus Finkel court case, the Supreme Court clarified that regardless of whether the employee occupies a policymaking or confidential positions, party affiliation must be necessary for effective performance of the job. So this happened when certain positions that the president requires, certain elected officials require certain positions where the bureaucrat at some level must be aligned with the political beliefs of that elected official, because only then can they run efficiently. They can run a government that they feel that the people have voted towards. So I believe it is under page 66, the last paragraph, but it says that you can dismiss based on patronage only if the person being discharged occupies a policy making or confidential position. So the Branti versus Finkel thing also talked about that party affiliation must be necessary for effective performance of the job. If you need to be a Republican to work under a Republican administration, then that works. So you can't you can't fire someone from FEMA because you don't need to be a Republican to work for FEMA, but you probably need to be a Republican to be in the president's cabinet. In some cases, just because the president has certain agendas that he or she has to fulfill, and those agendas might be aligned with the belief systems of his or her party if they're Republican or if they're Democrat. So the Branti versus Finkel court case kind of helps with that. Okay. Another law that we need to talk about is the FLSA, the Fair Labor Standard Act. And this requires that we must pay a minimum wage, at least a minimum at the federal level. Overtime must be paid if you work for more than 40 hours a week at time and a half. Most states actually have minimum wage that is above the federal minimum wage, and I think California is one of those states. However, if you have a white-collar exemption, which means you're making over $23,000, I believe, annually in your salary, you can qualify for a white-collar exemption, which means that you are engaged in a certain kind of job where you aren't paid by the hour, you are paid by the month, and it requires you to come in and maybe work more than 40 hours and maybe not receive overtime. So like I have a white-collar exemption. I'm sure some of you have a white-collar exemption if you are working in those kinds of positions. The Equal Pay Act, of course, requires employers to pay men and women equal wages for equal work unless the employer can justify the differential by seniority, merit, piecework, which means that, maybe one person is just doing way more work than the other in terms of the amount of widgets that they're coming up, or any other factor apart from sex. So as long as gender isn't being the sole determinant of why someone is getting paid more than the other person, then the Equal Pay Act does not apply. Workman's compensation, again, a really important coverage. It is a no-fault compensation where all workers in federal agencies, if they're injured, receive health care and lost wages. At the same time, which means that even if the worker was at fault and received an injury, he or she is eligible for workman's comp. At the same time, the employee does relinquish the right to sue the employer in civil courts for on-the-job injuries, while the employers forfeit the right to deny benefits to employers whose own negligence caused or contributed to the injury. Now, that is only in civil court. So in federal court, if you can demonstrate clear and present danger that was willfully ignored by the employer, then it's a completely different sort of issue. Health insurance, public employers are obligated to provide health insurance, and obligated not just to provide health insurance, but provide health insurance at incredibly discounted sort of rates where they pay the majority of the premiums. The same thing with ERISA, or the Employment Retirement Income Security Act, which we are exempt from, which basically requires employers to pay men and women. The Employment Retirement Income Act is the main federal law governing private sector pensions, but no public sector counterparts exist. As a result, when a government reduces pension benefits, constitutional provisions